Kıymetli misafirlerimiz, saygıdeğer hocalarımız ve bizleri çevrim platformlardan takip eden değerli takipçilerimiz. Sempozyumumuzun Gelibolu Konferans Salonu'ndaki birinci oturumu Cezayir Üniversitesi'nden saygıdeğer hocamız Profesör Doktor Necibe Bukumeci'ye başkanlığında gerçekleşecektir. Fikri mülkiyet hukuku alanında doğayan isimler arasında yer alan Profesör Doktor Necibe Bukumeci'ye Cezayir Yüksek Hakimlik Okulu ve Cezayir Üniversitesi'nde öğretim üyesi olarak görev yapmaktadır. Çeşitli uluslararası kadın hakları derneklerinin üyesi olan Hukukunda, bilgi ve iletişim teknolojileri sektöründe ilişkin uyuşmazlıklar alanında uzmandır. Çok sayıda hukuk kitabı kaleme almış ve saygın uluslararası dergilerde 50'ye aşkın makale yayınlamıştır. Ayrıca pek çok araştırma konusunda üye ve başkan olarak yer almaktadır. Bu oturumda ayrıca Uluslararası Vizyon Üniversitesi'nden doçent doktor Jordan Delev, Kırgızistan Ulusal Üniversitesi'nden öğretim görevlisi Elvira Almikulova, Taşkent Devlet Hukuk Üniversitesi'nden öğretim görevlisi Adamat Berdum Muratov sunumlarını bizlerle paylaşacaktır. Our valuable guests, SM Professor and valued editors who are following us from online platforms. The first season of our symposium will be moderated by our SM Professor, Professor Dr. Najiba Bukameja, from University of Algiers. Professor Dr. Najiba Bukameja, one of the leading figures in the field of intellectual property law, served as professor at the Higher School of Magistracy in Algeria and the University of Algiers. She is a member of several international women's rights associations and an expert in the litigation concerning the informal and communication technology sector. Wikimedia has authored numerous legal books and publishes more than 50 articles in reputable international journals. She is also serves as a member and chair of various research committees. In this season, Associate Professor Dr. Jordan Delev from International Vision University, Lecturer Elvira Almikulova from Kyrgyz National University, Lecturer Azamat Berdi Muratov from Tashkent State University of will share their presentations with us. Bütün dinleyicilerimize verimli bir oturum duruyor ve sözü Sayın Oturum Başkanımıza bırakıyorum. I wish a productive season to all our listeners and I'll leave the floor to our esteemed moderators. Thank you.
Thank you so much for your introducing. Thank you for the advice and staff. Thank you for the Faculty of Law. Thank you for distinguished colleague. When was also Mr. Omar and Mr. Rezif and all the team. Thank you for students and all guests. We start by the first presentation of Professor Jordan Geli, entitled Trademark Ownership of Identity-Based Sales in Professional Sports, an analysis of the RF logo campus.
Bana yardımcı olabilir misiniz? Evet. Sunumunu başlatabilir misiniz? Aha, tamam, onu ben halledebilirim.
Pardon.
Before I starting, I want to thank you to all the organizers and for this opportunity to have like really productive sessions with contemporary law matters in intellectual property. So My presentation with it is related to trademarks, and it is concentrated on identity-based science in professional sports. And this will be analysis of the era logo case. Um, okay. Um, Here, the main question is of who should legally own the trademark when the trademark is inseparable from the individual person identity, when actually the mark is in the person, and this constitutes a legal problem. So this question is not merely theoretical, and the dispute between the tennis legend Roger Federer and his former sponsor Nike over ownership of stylized RF monogram logo crystallized this tension in the unusual clarity. So there will be two main research questions. The first one is how does trademark determines on the ownership of identity-based science, and what principles govern the acquisition, assessment, enforcement of the right in as such. And the second one is it will be the current legal framework adequately reflect the personal association and goodwill that an athlete identity contributes to the commercial value in the sign. Because we are kind of time limited, so I will just say uh, conceptual framework. So identity-based science is a distinct conceptual category are those marks whose primary sources of commercial meaning and distinctiveness is derived from person's identity rather than from goods or services with which they are associated. So now I will move directly to the RF logo case. This will be examined from several portions. The first part is the creation of in registration. So the era RF logo was created in 2008 by Nike's design team in the context of the long-standing sponsorship relation between Nike and Roger Federer that had been placed since 1994. While Federer was publicly stated that he was involved in the design process, this kind of statement doesn't came from Nike, and formal intellectual property ownership vested entirely in Nike by virtue of registration. Federer owned the trademarks in his full name, like Roger Federer as an European Union trademark and his signature, but he had not registered his initials, RF, as a standalone mark. The second focus it will be on the commercial exploration and public association. So between 2010, when RF logo was first used commercially, and 2028, when the Federer Nike relationship ended, the mark was deployed across a wide range of Nike products such as clothing, footwear, headwears, and other accessories in global commercial campaign that develops one of the most recognizable personal logos in sports. So in 2028, there was like that RS brand is like approximately $27 million, and the logo had become, accordingly to legal commentators, one of the most recognizable and distinctive sites in the world of tennis and sports in general. From the other side, the consumer perception surveys on the market studies, they were not publicly reported in the context of the dispute, but the circumstantial evidence of this association was overwhelming because the fans in Wimbledon 2028 were observed carrying makeshift signs bearing the RF logo in support of Federer despite his absence for Nike apparel, and the logo's commercial deployment was understood universally as a reference to Federer as an individual rather than the Nike as a commercial source. The next focus is the termination of the sponsorship and legal consequence. So this will be here. I made the parallel between UK Trademark Act and European Union Trademark Regulation. So UK Trademark Act says that one legal avenue potentially available to Federer was all main defense available under this act. But from the point from the European regulation, which allows a natural person to use their own name in the course of trade provided that using the accordance with honest practices in industrial commercial matters. So legal commentators were very skeptical, however, whether this defense would be available to Federer in these circumstances. First, it was questionable whether defense framed around use of all natural person's name would extend to the use of stylized initials as a separate graphic mark. And second was given that the pre-existing contractual relation governing use the era of logo marks continues by Federer without Nike's consent, not readably be characterized as a use in accordance with the honest practice. So, in addition to this, the legal complication arose from the prospect that having ceased sponsoring Federer, Nike's continued to use the era trademark on a tennis product could itself have been legally problematic because legal scholars notes that continued exploitation of era logo by Nike in absence of any ongoing relationship with Federer risk constituting deceptive use under the regulators insofar as a consumer encountering the logo would be misled into believing continuing enhancement relationship existed. So how it will be it finished on the assignment to the Tenro AG, and this was the resolution of this dispute in February 2020. After approximately 2 years of negotiation, Nike assigned all trademark registration for the RF logo in jurisdiction across the globe, which means including US Patent and Trademark Office, the Swiss Trademark Register, and European Union Trademark also, to Tenro AG, which is Federer's intellectual property management company incorporated in Switzerland. This case brings us some doctrinal tensions. These tensions, the first is identity versus registration. So, this case most directly illuminates the tension between the factual basics of marks commercial significance and the legal basis of trademark ownership, which is formal registration. Trademark owner, as currently structured, does not distinguish between marks whose commercial meaning delivers from corporate investment and marks whose commercial meaning derives from an individual personal identity. The categories of marks are subject to the same registration rules, and ownership follows from registration rather from the source of the mark commercial value. The second tension is goodwill and consumer protection. So, the goodwill of RF mark, the consumer recognition and loyalty that gave the mark its commercial value, raised ambitiously in favor its identity and reputation. When Nike attempted to continue marketing RF branded goods after the expiration of its sponsorship agreement, it risks appropriating goodwill that it cannot independently create and could not longer sustain without federates continued association. This situation exposes a limitation of the contextual apparatus of goodwill as deployed in trademark law. Goodwill doctrine was developed in the context of businesses, where the goodwill associated with marks attached to the enterprise and all the commercial operation. When the marks goodwill attached to the individual rather to the enterprise and when it inherits personal goodwill, the convention analysis becomes like strained. And the third doctrinal tensions here, it is the intersection between personality rights. So Arab logo create an inadequacy of current division between trademark law and personality rights as a framework of protecting identity-based commercial interests. In jurisdiction that recognize a right of ownership, an individual has exclusive control of the commercial use of their name, image, and likeness. This is more in common law countries, and right of the publicity as a cause of action address precisely the current interest as a stake in RF logo situation and the exploitation of individual identity for commercial purposes without their consent. Well, here is a little comparative theoretical reflection from the US perspective and from European perspective. The US perspective is a publicity rights and personal branding, and European perspective is trademark centered protection. So the United States presents a legal environment in which athletes seeking to protect identity-based marks have access to richer array of legal instruments than European counterparts. The Rouse University recognizes under the statutes in jurisdiction including California and Europe provides and calls protection for the unauthorized commercial use of an individual name, likeness, or other aspect of personal identity. European trademark law, which was harmonized to the regulation, and of course its procedures instrument centers its protective framework on registered proprietor without extending equivalent independent protection to personal identity. According to this regulation, claim defense provides a limited exception permitting natural person to use their own name in trade, but the analysis of current case confirms this defense is narrow application and does not extend to prevent registered appropriated from enforcing its rights against that individual whose identity the marks reflects where the prior control relationship that govern in the mark creation and use. This case arises some kind of potential reform, which the reform should be structured in three directions. So the first one is trademark registration could introduce a category like personal identity marks. Mark constituted by an individual name, initial signature, or likenesses, and require that the registration of such mark incorporate name be accompanied by express written contains for individual concerns. The second trademark law adopt a reversion mechanism analogous to the copyright termination rules, under which the individual whose identity constitutes a mark retains the right to reclaim ownership upon expiration of any commercial arrangement, regardless of the terms of the initial registration. And the third, at the level of the professional sport practice, governing bodies and athletes association should mandate the inclusion of automatic assignment clause. So provisions that expiration or termination of sponsorship agreement automatically transfer ownership of identity-based mark to the athlete or their designated IP holding entity. As a conclusion, we can conclude this from athlete perspective, from sponsoring corporation, and from for the trademark fee. For athletes, the practical implication of this case is clear. Identity-based marks must be registered proactively in athletes' own name or in the name on personal IP holding entity. At the earliest opportunity, and sponsorship agreement should include explicit provisions governing IP ownership. For sponsoring corporation, the case illustrated that ownership identity-based marks carries a legal and commercial complex legacy. So marks whose value derived entirely from the individual identity is not ordinarily commercial asset, but relatively relational one whose continued commercial utility is contingent on the ongoing association that with that individual. And for trademark doctrine, the RF case is invitation to recognize whether the neutrality of registration based ownership rules adequately serves the range of interest at stake in the commercialization of the personal identity. The conclusion is that it does not, and that the case support a normative argument for targets legislative or contractual reform that gives legal recognition for the distinctive characters of mark is separable from personal identity. Such reforms could not disturb the fundamental architecture of the trademark law, but would introduce at the margins protection that is more accurately reflect the relation nature of the goodwill associated with the identity-based trademarks. And in doing so, provide athletes with more secure legal foundation for the long-term control of the personal symbols that are in the federer's own war theirs. Thank you very much for your attention.
Thank you so much, Professor Jordan, for your presentation. Your presentation focuses on the legal complexity of trademarks that are directly linked to the athlete's identity, using the famous RF logo of Roger Federer as a key example. The speaker explained how, in many cases, sponsorship agreements give ownership of these trademarks to companies rather than to the athletes themselves. So the presentation raises an important question about whether current legal frameworks and really adapts to this modern reality. Thank you so much again for your engaging presentation. Now let's move to a very interesting topic about IP in Kyrgyzstan. Challenges and prospects will be presented by Professor Elvira Alkolova. You're welcome. Thank you.
Welcome. Sayın konuklar, değerli meslek hostalarım. Balıkesir Üniversitesi sahipliğinde düzenlenen fikri mülkiyet hukukunda güncel gelişmeler 4. Uluslararası Sempozyumunda sizlerle bir arada bulunmaktan büyük onur duyuyorum. Organizasyonunda emeği geçen herkesi teşekkür eder. Sempozyumunun tüm katılımcılar için verimli geçesinin dilerim. Fikirli mülkiyet modern toplumun ayrılmaz bir parçası olup bilgiye dayalı ekonomi ve inovasyasında kilit bir rol oynamaktadır. Son 10 yıllarda Kırgız Cumhuriyeti fikri mülkiyetinin görünüşünü olan ilgi artmış olup bu durum pazarların küreselleşmesi ve teknolojik gelişmelerden hızlanmasıyla temsilmektedir. Ancak yasal düzenlemelerdekinde ilgililerge rağmen fikri mülkiyet haklarının görünüşü konusu ülkede hala gülceğinin korunmaktadır. Fikri mülkiyet buluşlar, bilimsel keşifler, ticari markalar, telif eserleri, bilgisayar programları, veri tanaları ve fikri faaliyetinin diğer sonuçları üzerinde tanım haklarının bütündür. Kırgız Cumhuriyeti'nde fikri mülkiyetinin görünüşü ulusal ve uluslararası standartlarına dayanmaktadır. Bunların arasında bir sözleşmesi, Dünya Fikri Mülkiyet Örgütü sözleşmeleri ve patent işbirliği anlaşması gibi uluslararası anlaşmalar yer almaktadır. Kırgızistan'da fikri mülkiyet hakları aşağıdaki temel yasal düzenlemelerge yöneltilmektedir. Kırgız Cumhuriyeti Medeni Kanunu, ticari markalar, hizmet markaları ve malların menşe adları hakkında kanun, telif hakkı ve ilgili haklar hakkında kanun, patentler hakkında kanun. Ayrıca Dünya Ticaret Örgütü'nün bir üyesi olarak Kırgızistan, ulusal yasalarının uluslararası standartlarına uyum hale getirini anlaşmasını taraf olunmuştur. Mevcut yasal çerçeveye rağmen fikri mülkiyetinin etnin bir şekilde görünüşünün önünde aşağıdaki sonular durmaktadır. Toplumunda ve iş dünyasında düşük farkındalık seviyesi, birçok yazar ve mücül patent bulmakta veya ticari markalarını tescil etmektedir. Bu durum emlaklerinin yasa dışı kullanılmasına yol açmaktadır. Yargısal korumanın yetersizliği, ihlak vakalarında yasal mekanizmlerin yetersiz kalmakta, mahkeme süreçleri uzun sürmekte ve çoğu zaman haklar tam anlamıyla korunmaktadır. Teknik ve personel sorunları, patent kurumlarında modern ekipman ve yüksek nitelikli uzman eksiliği görülmektedir. Sorunlardan çözüm yolları. Bu sorunlardan giderilmesi için aşağıdaki önlemler önerilmektedir. Fikri mülkiyetin tescil ettirilmesinin önemi hakkında bildirmeginde çalışmalarının güçlendirilmesine ve yetim programaları konularının dahil edilmesi, yargı sistemasının iyileştirmesi, yasalarda geliştirmesi ve alanında uzmanlanmış hakimlerinin yetirilmesi, Kırgızistan'da alanında bağımsız bir mahkeme bulunmaktadır. Kırgızistan'dan yargı sistemi şu kademlerden oluşu, yer mahkemeler, bölge büyük şehir mahkemeleri, Kırgız Cumhuriyeti Yüksek Mahkemesi, uluslar işbirliğinin geliştirmesi, Dünya Fikri Mülkü Örgütü gibi uyumlar çalışmak önemlidir. Patent ve tescil sistemasının dijitallaştırılması, çevre içi platformaların ve elektronik veri tabanlarının hayata getirmesi süreçleri hızlandıracak. Aa, Son son yıllarda Kırgızistan'da fikri mülkiyet alanındaki alandaki yasal sistem önemli ölçüdeki güç güçlendirilmiştir. Bu değişti telif hakları, buluşlar, faydalı modeller, endüstriyel tasarılar ve ticari markaları kapsamaktadır. Özellikle aşağıdaki alanlarda yenilmelerge kayıt edilmektedir. Hak tescil prosedürlerinin iyileştirmesi, yasalardan uluslararası standartlarına uyum hale getirmesi, hak sahiplerinin koruma mekanizmalarının geliştirmesi, dijital teknolojilerinin kullanması, uzun vadeli önemi. Fikri mülkiyetin gelişmesi gelecekte sonuçları beraberinde getirecektir. İnovatif ekonomikanın geliştirmesi, yabancı yatırımlarının çekilmesi, yerel üreticilerin rekabet gücünün artması. Praktik öneriler. Kırgızistan'da fikri mülkiyet haklarının ihlaline genellikle ticaret ve yeme içme sektörlerinde rastlanmaktadır. Örneğin Bişkek'te dünyaca ünlü markalar benzer isimlerin yasa dışı olarak kullanıldığı durumlar kaydelenmiştir. Bir eğilimler tüketicinin yalatmakta ve ürünlerin menşei hakkında yanlış bilgi vermektedir. Ham sahipleri mahkeme başvurarak bu talepleri bulunmaktadır. Yasa dışı kuplamanın duruldaması, tazminat taksili, sahte ürünlerimin ihmal edilmesi, yargı uygulamaları benzer işaretlerin kullanması durumunda bir ihmal olduğu kabul etmektedir. Ancak kanıtlama süreci karmaşık ve uzun sürmektedir. Bunun yanı sıra özellikle dijital ortamda telif hakkında ihlaller de yakında. Eğitim materyallarının yasa dışı kullanması, bilimsel çalışmalardan kopyalaması, lisanssız programmalardan ve filmlerin dağılması, bu durumlar telif hakkı hakkında kanunun varlığına rağmen hukuk kültürünün düşülüğü ve mahkeme başvurma sayısının azlığı ile çıkmaktadır. Sonun Kırgızistan'da fikri mülkiyetin korunması, bilgi dayalı bir ekonominin inşasında temel bir faktördür. Bu alanın daha fazla geliştirmesi gerektirmektedir. Yasal tayyaptın güçlendirmesi, hukuku korumanın artılması ve hukuku kültürünün yükselmesi, inovasyonların gelişmesini ve ulusal ekonomikanın büyüsüne zemin hazırlayacaktır. Kapanış sözlerinden tamamlarken bilimsel bilginin faydalıkça çoğaldığına olan inançı vurgulamak isterdim. Bu sempozyumun düzenlemesinde emeği geçen Balıkesir Üniversitesi'ne ne partner kurumlar, şahsıma gösteriniz nazik misafirperverliğine en kalbi şükürlerine sunarım. Mefrum Samih Kaçmaz kardeşimiz dediği gibi akademik bir kayçanla fikirlerin özgürce üretildiği ve adalette göründüğü bir dünya temennisi ile dildiğiniz için tenderim ederim. Teşekkürler.
Thank you, Professor. Well, thank you, Professor Ilya, for your presentation. You this is like related to your PPT. I understand the presentation highlights how important it is for innovation and economic growth in Kyrgyzstan. The speaker explained that even though the country has linked its laws with international standards, like TRIPS and Y2GTs, the speaker also proposes practical solutions such as I think such as improving education about IP, strengthening the digital system, and increasing international cooperation of your country. Thank you for your insightful and well-structured presentation. Now let's continue with the presentation on creative brands, identity and trademarks protection, legal challenges and perspectives in the intellectual property system of Uzbekistan by Azamat, Professor Azamat Berdi Muratov. You're welcome.
Distinguished colleagues, dear participants of the symposium, uh, merhabalar. It's a great honor for me to address you today a subject that lies at the heart of modern legal and economic development, the protection of trademarks and creative brands in the intellectual property system of Uzbekistan. And today I will share findings from my research on the legal challenges and prospects of trademarks protection in my country. And I will draw extensively on the experience of Japan as a comparative reference. So why I choose Japan like for a comparative reference? Because Uzbekistan and Japan, they are similar in civil law jurisdiction. Also, we have a Roman German system. And so I decided to make a comparative analysis of Uzbekistan and Japan. Okay. In Uzbekistan, last year in 2025, were registered more than 6,000 trademarks. And trademarks are not only commercial assets. And I want to say that to highlight three reasons why this topic is urgent. First, commercial value. Trademarks distinguish goods, build reputation, and sustain competition in market economy. Second, uh, this is a conceptual core of my paper. Creative expression, logos, graphics, and stylized marks are works of art created by designers. They merit both trademarks and copyright protection. Third, consumer trust. Uh, Counterfeit trademarks deceive consumer, harm health, and sensitive sectors such as medicine, cosmetics, foods, and undermine confidence of brands. My research question of my research. First, is the trademark law of Uzbekistan adequately designed and effectively implemented to protect exclusive rights of trademark owners? Second question is, where exactly are the substantive and enforcement gaps? And third research question is, what can Uzbekistan learn from Japan, like a civil law jurisdiction with a robust IP enforcement ecosystem? Okay, brand identity. Uh, Allow me to dwell on the conceptual core of my paper. Okay, trademark in a classic legal sense, it's a perform three function. It's distinguish goods, guarantees quality, and serves as a advertising. It is in essence a source identifier, but A trademark in the modern economy is rarely just a word. It is logo, a graphic, stylized image created by a designer with originality, with artistic choice. From the perspective of corporate law, that logo is a creative work. Uh, uh, Uzbekistan's and I will talk about Uzbekistan IP framework. Um, and the timeline you see covers more than 3 decades of development. Uzbekistan joined uh, WIPO, World Intellectual Property Organization, in 1991. The law, the very first year of independence in 2001, our specialized trademark law was adopted, and in 2022, by presidential decision of Uzbekistan, the Intellectual Property Agency was integrated into the Ministry of Justice. Now the responsible body of IP protection in Uzbekistan is Ministry of Justice. Then in 2022, Uzbekistan adopted a new constitution for the first time at the constitutional level. Article 53 of Constitution declares that intellectual property is protected by law. This powerful symbolic and normative signal. And in 2024, after 24 years on the United States Special 301 watch list, Uzbekistan was finally removed, recognizing a progress made. Next. And here we arrive at the pivot of my talk. On the left side of the slide, uh, uh, the law on the books. Substantive law in Uzbekistan is largely adequate. We have the civil code, the trademark law of 2001, constitutional protection, recent custom code amendments from February 2024, and our legislation is broadly aligned with TRIPS, the Paris Convention, and the Madrid Protocol. On the right side, the law in action, and this where the deficiencies appear. Counterfeit goods are widespread in pharmaceuticals, fashion, and fast-moving consumer goods. Remedies are limited, and enforcement inconsistent. Interagency cooperation is weak. Public awareness of intellectual property rights remains low, and we observe brand riding and abuse of well-known trademarks. The real frontier of trademark protection in Uzbekistan today is not what the law says, it's how the law works in practice. This slide shows you real cases. I will talk about Nestle and Family Group case. First, Nestle and Family Group decided in 2016 by the Economic Court of Tashkent. This was a bottled water case. The court accepted as evidence a consumer survey of 300 respondents conducted in Tashkent, Samarkand, and Andijan. Of those respondents, 58.5% confused the two trademarks. Of those, 94% associated the mark with Nestle. On this basis, the court granted an injunction. To this day, this is the first and only major Uzbek case using consumer survey as a evidence, and it's a model that has not yet been institutionalized. Okay, here you can see the 5 categories of legal challenges. Drawing on this case and my doctoral analysis, my research identifies 5 categories of legal challenges. Number one, weak legal regulation. The trademark law of 2001 functioned as a so-called framework law. It's short on operation rules, and many of those rules are dispersed across bylaws, presidential decrees, and ministerial orders. Number two is difficulties in law enforcement. the application of regulation is hindered by their imperfect framework character and, in some respect, their obsolescence. Number three is limited powers of state bodies. Competence is unclear, interagency cooperation is weak, and authorized bodies rarely act on their own initiative to monitor the market. Number four is ineffective court remedies. Liability measures are insufficient, and trademark cases are scattered across civil, economic, administrative, and criminal codes, producing inconsistent practice. So in Uzbekistan, we don't have IP courts. Number five, uh, law awareness and non-registration of trademark. Both infringers and trademark owners often lack basic knowledge. Many marks remain unregistered and therefore vulnerable. Uh, Here is the most recent and most important development in our country. On the 8th of August 2025, in Uzbekistan was adopted a law, a comprehensive reform in intellectual property legislation. This reform introduced for the first time criminal liability for trademark infringement through three new articles in criminal code. They are illegal use of trademarks, use of well-known trademarks, aggregative cases. Okay. However, I had a field work at the Ministry of Justice last year. Uh, through uh, Through the internship field work in the Ministry of Justice, I found practical issues, practical problems. First, there is no standardized methodology of determining confusing similarity. Judges typically request expert opinion from the Ministry of Justice. Consumer surveys, the evidentiary gold standard in major jurisdiction, have been publicly used only once, in one case in 2016, Nestle and a family case. Second, there is no methodology for quantification of damage. Prosecutors lack clear guidelines to establish uh, the material element required by the new criminal offenses. Third, the business ombudsman bottleneck. Since 2017, no inspection of a business may be conducted without prior coordination with the business ombudsman. This protects entrepreneurs from arbitrary state action, legitimate aim, but it's also introduced delays. By the time inspectors arrive, infringers may have concealed counterfeit stocks. It's mean before the inspection of entrepreneurs, Ministry of Justice uh, should notify business ombudsman about the future inspection, and this notification also can be seen by the infringer, and infringer can hide, for example, counterfeit goods. Next, the controlled purchase tool, which is Ministry's principal operational instrument, is itself slow. After a test purchase, inspectors must contact the right holders. Right holders often respond slowly. The window for the action narrows. And the fifth, warehouse inspections generally require the consent of the owner, which further constrain enforcement react. Okay, here is a little about legislation of Japan, comparative analysis of Japan. Pillar one, legislative architecture in Japan is very good. It, uh, and Japan operates with two complementary statutes, the Trademark Act of 1959 and the Unfair Competition Prevention Act. Trademark Act of 1959 was a called directly applicable law. In contrast to the framework law of Uzbekistan, it's self-executing. it doesn't require additional regulation to operate. Then the Unfair Competition Prevention Act of 1993 protects what the Trademark Act cannot reach. Unregistered trademarks, even without registration, a sign that has acquired distinctiveness may be protected. Pillar number 2, plural remedies and evidentiary tools. Japanese law offers 3 layers of remedies. Civil remedies include injunction under the Article 36 of the Trademark Act. Uh, then administrative remedies include trial and appeal proceedings before Japan Patent Office, invalidation trials, rescission of non-use after 3 years, and criminal remedies, as I mentioned, can reach 10 million yen and 10 years imprisonment, a strong deterrent. Okay, next slide. Uh, institutional ecosystem and culture. Uh, the Japan Patent Office was established in 1885, almost 140 years and accumulated expertise. The IP High Court has functioned since 2005 as Japan's first specialized intellectual property court. It has appellate jurisdiction over civil IP cases and first instance jurisdiction over administrative challenge to JPO decision, which ensures uniform jurisdiction. But beyond institutions, there are something equality important. It's a culture. Japan celebrates World IP Day publicly. There are media campaign. There is intellectual property education from primary school. There are training programs for legal practitioners and small and medium sized enterprises. Here is a slide about recommendations for Uzbekistan. Drawing on these 3 Japanese pillars, my recommendations for Uzbekistan are organized in a parallel. On substantive law, pillar 1, transform the trademark law from framework law into a directly applicable code by adding provision on injunction, damage calculation, and definition of unfair use. Second, on remedies and evidence, pillar 2, operationalists and new criminal articles with clear methodology for damage calculation and confusing similarity. Introduce a regulatory on consumer survey evidence building on the Nestle precedent and on Japanese practice. And next, on institutional and cultural pillar, develop a workable model that reconciles business ombudsman protection with effective enforcement, and invest in building a culture of respect for intellectual property through media. Yes, thank you very much. And if you have questions, please. I'm ready to. Thank you.
Thank you, Professor, so much for the invitation. In this presentation, the speaker explained that trademarks are not only related to business tool, but also it can be related to creative expressions often linked to maybe copyright law. The study shows that Uzbekistan has made progress in developing its legal framework and bringing it with international standards. The speaker advised that improving trademark protection is essential not only for business but also for creativity, innovation, and economic growth. So thank you so much for this clear and informative presentation. Then, if thank you also for all the speakers. If there are any questions, of course, you can open the question session. Yes. Is Professor Jacobi.
Congratulations to all the speakers. On this round, we are absolutely from the time constraint, but wanted to briefly react to also Jordan's presentation. It was it's great to hear about the Swiss hero and what is attributes to the Roger Federer trademark issue. And my question was about the potential to apply this concept of deceptive trademark to which you referred, um, which could mean that Nike could be using potentially the art trademark after the termination of the sponsorship agreement on the basis that the continued use of the trademark could be deceptive. And I wanted to have your thought in that, knowing that, just a side note from a European perspective, this is, as we have previously discussed, I actually
Yeah.
yesterday, this is something which is discussed not in the sports industry, but more in the fashion industry,
Yeah.
where there are cases, high-profile cases, including one with Turkish Devajat, like this fashion designer, French fashion designer, and I was wondering whether you think that would potentially apply Kubrick drive also in your
First of all, thank you for question. And yeah, it is really nice perspective how you bring the question. So the first part of the question, like there was legally Nike can use the RF logo because they were the owner, but they were losing clients because this could become a little more than little bit like because so publicly so the perception of the consumers was this RF logo. Yeah, it is owned by Nike, but represents Roger Federer. So if Roger Federer is not a part of the Nike's team or is not representing anymore, so they are losing their own image that they built across all these years. So they were kindly they don't want it to use anymore. So this section, and maybe this was the main point that they settled. How we don't know the result of the settlement; it is confidential. And yeah, I completely agree with you when it comes to the designers also. Yeah, we have such kind of cases as well, but the perception there is a little bit different because when it comes to the sports, when it comes to the athletes, it is more identity based. So the relation between the goodwill of the trademark, like the relation between consumer perspective is directly to the athletes. So I think in my research, I didn't took your example, but there was like a designer house, I think is Karen Miller. So the perception that was different, like it was more to the fashion brand, to the fashion house than to the name. So that has had a slightly bit difference than this identity-based science. For me, is the main problem here is the contractual asymmetries on the beginning of their careers. So athletes are not that ready, or they don't know their potential in the beginning. So introducing these kinds of clauses maybe is better. So if you saw the last transfer to Stephen Curry transfer from Under Armour to Nike, there is no dispute. So maybe we don't know the agreement still, but maybe this kind introducing because for my opinion, this will be remained on the contractual side. So the sponsorship agreement should make like IP clauses inside this and to be drafted in that way. That was my answer. Thank you very much again.
So thanks for the presentations. I would like to ask a question to our last speakers. My question is, I really appreciate your comparison, but I wonder whether your argument would be stronger because I believe that obviously the system in Uzbekistan is still developing. I wonder whether what you are mostly referring to in terms of enforcement is counterfeited products. I think the real problem might be counterfeited or almost look alike, rather than potentially innocent infringement and so on. So I wonder to what extent perhaps the comparison could be stronger in terms of strength of the argument if you could focus more on the counterfeited part because that's what is more harmful for Uzbekistan economy. My fear is that too much enforcement can actually stifle competition and be bad for Uzbek consumer because I guess a lot of the fakes come from famous marks from abroad. And the fakes are largely probably some might be made in Uzbekistan, but most are not. So it's eating down. It's a battle of titans between good famous foreign marks and then the imports of fake products. And that's what bad for Uzbekistan market. But I wonder to what extent to have too much enforcement can actually be of unintended consequences because then if you don't have the balancing of preferential use, freedom of expression, strong potential fair use of, that becomes a problem. Too much of it, business is always trying to over enforce. So you have somewhat to protect to get to a beneficial. And if you put a lot of national resources to defend foreign trademarks, there is also a diversion of national funds that might not be in the best interest of Uzbekistan directly. It might be for foreign investment or other things. So I wonder to what extent you could fine tune a bit the difference between fake and counterfeited with some numbers about okay, how much of a real company is that? You know? Because Japan has strong exceptions as well. So I think in Japan, remember, is a country that lives by coffee, and that becomes very well. So you need to have that space in it. So that's my question. My maybe my suggestion slash question. Thank you.
Thank you very much. Thank you very much for recommendations. And I can say that in Uzbekistan we should have a balance between culture of on-trade legislation and law enforcement practice. So I will totally agree with you. And first of all, we should train our consumers, maybe entrepreneurs, to reach law. It's about culture of obeying law and to explain them the importance of the ID. Thank you very much. Thank you for the recommendation.
Değerli katkılarından dolayı hocalarımıza teşekkür ediyoruz ve plaketlerini takdim etmek üzere İstanbul Sabahattin Zahi Üniversitesi Tıp Fakültesi Dekanı Sayın Profesör Doktor Canan Küçükali'yi sahneye davet ediyorum. Professor Dr. Canan Küçükali, Dean of the Faculty of Law at Istanbul Sabahattin Zahi University, is now presenting the certificates of the appreciation to our distinguished speakers. also with some announcements, which is due to time limits, we will prepare to directly the second season without a break. Thank you for understanding. Zaman limitleri sebebiyle Adana'dan direkt diğer oturumumuza devam edeceğiz. Teşekkür ederiz. Hı hı. Bir tanesi de online olacak. Online da mı?
Gelmeyecek. İsmi de okunmasın. Bir kere konuşmaya sonra.
Sadece.
Tamam.
Babam da aynı şey.
Var mıydı hatırlamıyorum çok fazla ama.
Şey,
Aynen buyurun.
hayır, tamam. Ne tür
Hocam kaçıncı? Şu an 2'ye başladık. Aynen. Ama bu kimin? Bu İngilizcesi değil mi? Bakmıştık evet, İngilizceyle. Tamam, İngilizce soruyorum. Evet, hiç sorun değil. Şöyle ne yapıyorlar?
Aşağıda mı olmuş? Şu anda
Hocam hemen kapatayım. Açabilirim orada. Tamam.
Can I?
Tamam.
Yeah. No, you need to. Oh yeah, you start.